Hi there, my name is Jennifer DiGiulianardo. I am a Housing Asset Manager Team Lead with the Colorado Division of Housing. Today I am joined by Erin McNabb, who is also an Asset Manager. Today we're going to be covering a summary of Colorado state statutes impacting landlords and renters. Before we dive in, we do want to stress that we are not attorneys or legal experts, and that you guys should always be going to your legal counsel for further guidance. The training is going to be a high-level review. So again, we're going to encourage our partners to go back to their legal counsel, read those statutes, and adopt those as necessary. We're going to be covering years 2022 to current. The handout that we've provided for this training includes statutes going back to 2021, but again, this presentation will not reference those that are older. We're going to focus on 2022 and current. Now, before we get started, I want to cover our agenda. We're going to be hitting on the applicant screening and eligibility, rent, deposits and fees, and tenant protections. So I will hand it over to Erin, who will start with how a bill becomes a law.
Good morning. We thought we'd cover how a bill becomes a law because it's been a few years since Schoolhouse Rock, and we could probably all do well with a refresher. So in order for a bill to become a law, it has to go through many steps. A bill must first pass the House and then the Senate. In both the House and the Senate, the bill must have a first reading, go to committee for a public hearing and reports, have a second reading and possible debate, and then have a third reading and final passage. After a bill passes the Senate, if there are no amendments, it goes to the governor to sign. If there are amendments, the bill will go to a conference committee. A conference committee works together to work out language that will be acceptable to the House and the Senate. A majority of the members must agree for the committee report to be submitted to the House and the Senate. The governor can choose to sign the bill, leave the bill unsigned, or veto the bill. If the bill is vetoed, the General Assembly must have 2/3 votes to override the veto. All right, applicant screening and eligibility. State Statute 3812-904 covers applicant screening requirements, deposits, and adds a defense for evictions. Section 1 sets a max 2 income requirements for eligibility to 2 times the annual cost of rent in annual income. This applies to all tenants, even those in market rate units. If a prospective tenant has a housing subsidy, defined as any portion of a rental payment that is derived from a public or private assistance, grant, or loan program, and that is paid by the program directly, indirectly, or on behalf of a tenant to a landlord, then their credit and rental history cannot be used as a reason to deny them for housing. As a clarification, nothing in this statute precludes a landlord who is receiving funding from a governmental entity, quasi-governmental entity, or a nonprofit organization that requires landlords to income qualify tenants for income-restricted rental units from gathering any financial information about a prospective tenant for the purpose of determining the prospective tenant's eligibility for an income-restricted rental unit if the funding source requires the landlord to collect such information as a condition for the receipt of funding. Section 3 states that if a landlord violates Section 3812-904, 1C, or 1D, they are subject to an initial penalty of $50 paid to the aggrieved person. If the violation is not cured, there's an additional penalty of $2,500 paid to the aggrieved person. Section 5 limits security deposits to a maximum of 2 times the monthly rent. And Section 6 adds language that allows a tenant who is facing eviction to assert that the landlord is violating state laws listed in Part 5 of Article 34 of Title 24 regarding unfair housing practices. And that is linked in the resources you will be provided, as it's quite long. State Statute 3812-902 requires landlords to accept portable screening reports from prospective tenants and to inform prospective tenants of their right to provide said report. Landlords must also include this notification in advertisements. If a tenant provides a screening report, the landlord may not charge an application fee. Reports must include the prospective tenant's name, contact information, verification of employment and income, last known address, rental history, credit history, and criminal background check. Landlords may require that the report was completed within the last 30 days, that the report is provided by the company that ran it directly to the landlord, and a statement from the prospective tenant that there have been no substantial changes to the information in the report. Landlords cannot be charged to accept the report and may not charge a fee to use the report. So here's some new rules about rents, deposits, and fees. Pet animal ownership and housing. State Statute CRS 38-12-106 states that landlords may not charge more than $300 for a pet deposit, and the deposit must be refundable. This statute also limits the amount of monthly pet rent that a landlord may charge to a maximum of $35 or 1.5% of the tenant's monthly rent, whichever is greater. And then return of security deposits. State Statute 38-12-103 states that a landlord has 1 month after the termination of a lease or surrender and acceptance of the premises, whichever occurs last, to return the full security deposit to the tenant. The lease agreement can specify a longer period of time, but it cannot be longer than 60 days. Landlords may not retain any of the deposit for normal wear and tear. If any portion is retained for reasons beyond wear and tear, the landlord must provide a statement listing the exact reason why a portion of the deposit was retained. The statement and the portion of the security deposit to be repaid must be paid within the 30 days or 60 days if stated in the lease agreement. If the deposit and statement are not returned within the specified time frame, the landlord forfeits the right to retain any portion of the deposit. Security deposits must be transferred to the new owner or returned to the tenant if the property is sold. Now I'm going to pass it over to Jennifer to go over the new tenant protection laws.
Awesome. Thank you, Erin. So with the issuance and return of summons, we have State Statute 13-40-111. And this statute states that after a complaint is filed by the landlord, the clerk of the court or the attorney shall issue a summons. This summons must describe appearing before the court at a place named in the summons and at a time or date not less than 14 days, but not more than 14 days from that issue of that summons. The statute is very prescribed in its language, so I'll read the first few sentences. However, I recommend that folks go to this statute. The summons must contain a statement to the defendant stating, if you do not respond to the landlord's complaint by filing a written answer with the court on or before the date and time in this summons, or appearing in the court at the date and time in this summons, the judge may enter a default judgment against you in favor of your landlord for possession. Now, there is more language to this, so again, I highly recommend visiting 13-40-111. Next, I am going to go to State Statute, excuse me, let me go back one. Making sure that State Statute 13-40-111, again, we want to make sure that that proper notice is given and that should payment be made available, that landlord shall accept payment of that full amount at any time until a court has ordered a writ of restitution. Now moving on to remote participation in residential evictions. Now in State Statute 1340-113.5, it states that the court shall allow either party and any witness to choose to appear in person or remotely by phone or video on a platform designated by the court. The statute also says that in an event that the party is disconnected or there's a technology failure, that the court shall make all reasonable efforts to contact that party and to allow reasonable time for the party to reestablish connection with the court. If that party is unable to reestablish connection, the court shall reschedule the hearing to be held in person for the first available date after the date of the originally scheduled hearing, but no later than 1 week after that originally scheduled hearing, as practicable. So quickly summarizing this one, wanting to make sure that folks have the option to proceed remotely, and then if any technical issues arise, that the court will work with them to the greatest extent feasible. Now, there are recent eviction protections for residential tenants. This can be found at State Statute 1340-110. And this states that for tenants receiving Social Security or other cash assistance established through the Colorado Work Program, requires mandatory mediation at no cost to that residential tenant by a neutral third party. Tenants may waive that mediation, but the lease cannot require that they waive that requirement. There is an exclusion for an eviction issued as a result of substantial lease violation, and that's for nonprofits, those 501c3s, and landlords with 5 or fewer rental properties. They're excluded from this statute. The statute also institutes new regulations about what can and cannot be included with a lease agreement. So definitely want you guys to dig into this further. And then we have the warranty of habitability for residential premises. This is State Statute 3812, 503, and 507. This eliminates the bond requirement for the warranty of habitability and allows the tenant to assert an alleged breach of the warranty of habitability as an affirmative defense. It establishes an allowable procedure and remedies in cases of an alleged breach of warranty of habitability. This statute requires a landlord to have a residential premise have it remediated to a condition that complies with the applicable standard for the remediation and cleanup of residential premises after damage due to an environmental public health event. Now, we went over those fairly quickly, so we want to give you the locations that you can find these resources. First, you can go to our webpage. The Office of Housing Finance and Sustainability is where our office is housed. So you'll start there, go to contractor and partner agency resources, go to forms and guidance, and then guidance and resources. We'll have a PDF that speaks to each of these statutes. We recommend reading these statutes at casetext.com, leg.colorado.gov with the Colorado Revised Statutes. And then these bottom two, I really think that it's worthwhile reading through those and comparing against your practices. We hope that folks feel comfortable asking questions. If you are in this webinar live, please go ahead and put your chats or your questions in the chat. Otherwise, please do reach out to your asset managers. Here's Erin and my contact information. However, if we are not your appropriate contacts, go ahead and follow this link at the very bottom of the page to ensure you have the right folks. With that, we hope everyone has a lovely day, and thank you so much for attending this training.